Welcome to another spaces this week. Today, the focus is on buyer power, and we have experts here from the Competition Authority, and we also have other guests here, some also from the Association of Kenya Suppliers and Red Truck also joining us for a conversation around this. The space is more motivated by what happened yesterday in terms of CAK issuing a determination on Carrefour and its use of buyer power. So we want to understand that in the context of that case and then be able to broaden it to the general retail space and just the general country as a whole to understand what the role of the competition authority in regulating competition in the country and what exactly they do in that regard. The discussion is centered around that, and there's been a lot of discussion online on whether 1 billion is quite a lot, but then we are going to understand in what relation does the CAK get to make this determination. To help us with this, we have two speakers. Mugambi is in the background a bit. So I'll let Dr. Priscilla start by introducing yourself first and what you do at CAK. And then Mugambi can also say what you do, and then Willie can also speak a little bit. So let's start with Dr. Priscilla.
Thank you very much for having me, Mwanamokaya. I work at the Competition Authority of Kenya. I am the manager buyer power department. And in a nutshell, the authority enforces, my department investigates. And so we investigate abuse of buyer power, like I said, one of the areas of enforcement under the Competition Act. There are 4 others, but today we focus on my area, abuse of buyer power.
Mugambi, introduce yourself.
My name is Mugambi Mutegi. I'm the manager in charge of communication and external relations at the CAK. Basically, my work is to spread the gospel about effective competition regulation in the country. Thank you very much.
Willie, over to you.
Thank you very much. My name is Willie Kimani. I'm here representing Red Truck. Truck is association that speaks on behalf of all the retailers, and that is from the smallest trader out there all the way to the biggest one, Naivas or a Quickmart or a Carrefour and all that. So all those are our members, and that's what we actually do. Personally, I've been in retail, having worked at Tuskys, Naivas for the longest, and now I have founded my own brand called Jazza that has around 6 stores. And so we are here to speak about what all this actually encompasses as far as buyer power and the supplier part of it and the retailers part of it. So welcome everyone.
Let's dive right into it. So maybe Mugambi, you can introduce to us what CAK does, and then for that I'll ask Dr. Priscilla to introduce what buyer power is.
Thank you, Eric. The Competition Authority of Kenya is a government agency. We are a regulator. We regulate market conduct and market structure. So market conduct, that's where you'll find us relating issues to do with abuse of dominance, cartel conduct, things like price fixing, bid rigging. So that's basically how the players in the market conduct themselves. Market structure is more or less mergers and acquisitions. We should be cognizant of the fact that how players maybe perhaps purchase each other or acquire each other could have a bearing on competition, and further down the line, a bearing on consumer welfare. Where parties are of a certain combined turnover or assets, we have to analyze the merger. We can approve it with conditions, or we can decline the merger. In terms of market conduct, there's also consumer protection. We have a consumer protection mandate. So things like misleading representations, lack of information being shared on products that we purchase. We had some of the matters that we recently handled. There's the bread issue with best before and such things, and false claims about what is contained in the bread. In juices sector, there are some people saying that the juices are 100% free, yet there's concentrate. There was a bit issue to do with cholesterol in edible oils. So more or less, that's what we do. Market conduct, market structure, technical terms, but I hope I've broken down a bit. So within market conduct, that's where buyer power sits, and I'll pass on the mic to my colleague, Dr. Priscilla Njako.
Just a second before Priscilla comes in, maybe you can give what are the global counterparts that you associate with, maybe so that do the same thing, maybe in the US market or in EU market.
We have a very cordial working relationship with the FTC in the United States, the CMA, Competition Markets Authority. The other one is in the UK, Korea, Japan, Competition Commission. Sometimes it's called antitrust law. Here in our market, we call it competition law, but more or less it's the same thing. In the continent, we have a very good working relationship with the FCC in Tanzania. There's one that is coming up in the East African region. There's a COMESA Competition Commission, then South Africa and also Egypt. We have even a local sort of grouping of competition agencies in the continent under the auspices of African Competition Forum, short ACF. Competition regulation across the world is normal practice.
Dr. Priscilla, now you can introduce to us buyer power and what it means, and then I'll come to you, Will, after that.
I'll start off with the definition under the Act, and then I'll break it down. I'll pull it apart so that then it makes more sense than it would under the Act. So the Act at Section 2 defines buyer power as influence exerted by a purchaser for a specific purpose to obtain from a supplier more favorable terms, or as when the relationship does not pan out as it should, to impose a long-term opportunity cost, such as harm or benefit that is withheld by that purchaser. And the Act says that there should be a difference in the long-term cost to the purchaser, or the opportunity cost had by the supplier should be significantly disproportionate to that resulting to the purchaser. And that's the Act. But buyer power simply refers to the ability of a powerful buyer to obtain advantageous terms of trade outside the scope of normal business practices. And these terms are likely to be disproportionate, unfair, detrimental to a supplier, or they could even be totally unrelated to the stated objective of the contract. So in a nutshell, it's simply the ability of a buyer to reduce a supplier's profitability below normal selling price, or generally obtain terms of supply more favorable than a supplier's ordinary contractual terms. In a sentence, the ability of a buyer to extract terms that they would not ordinarily extract if the relationship was not so skewed in favor of the buyer, in terms of they had a superior bargaining position.
And the abuse of it, how does it look like practically?
Now, the Act again presents us an open list. And so we interpret conducts that are not listed, of course, using the ones that are listed. Let me pick out a few that are listed. There's threat to terminate a commercial relationship, or actual unilateral termination of a commercial relationship without a reasonable justification. Another example would be refusal to accept goods. So that you have a buyer who has ordered goods, but when they are delivered, for one reason or the other, overstocking or just error, okay, they may decide, okay, fine, I ordered, but I'm sorry, you will have to go back with this. Transfer of costs, for instance, requiring a supplier to fund promotion costs, or send employees to work on the buyer's premises, or contribute to the cost of opening new branches. Transfer of commercial risks that should ordinarily be borne by the buyer. Okay, a transfer of those costs to the supplier. Let me give an example. You could have a situation where there's shrinkage while those goods have already been transferred and ownership has already moved to the buyer. And so these goods are in the buyer's premises, and there's shrinkage, loss of whatever nature, however caused, but not caused by the supplier's fault. And then the requirement then, because of the existence of buyer power, is that this supplier bear the cost of the loss of the goods. And so these are risks. That's a risk that should actually be borne by the buyer, and it's being pushed to the supplier. And of course, the one we are all familiar with, delay of payments.
All right. We'll come back to that. Really, I wanted to hear from you in terms of maybe the retail space in Kenya. You can map it out for us a little bit and then speak about buyer power in that retail space.
So, first and foremost, to appreciate and actually say that in retail, it's all about the actual selling of the product. It's all about being the channel to the end consumer, the true last mile, where we are breaking the bulk and presenting the actual products out there. So how is the retail market scope looks like? It's a 70-30%. So 70% is what is called general trade, and there's 30% what is called modern trade. So that 30% modern trade, that's where you'll now find the modern traders and modern retailers, that your Quick Marts, your Naivases, your Carrefours, and everyone now sits in that particular space. Though when you look at it from another angle, which is by Sagachi, it actually says that modern trade is not even 30%, it's around 18%. So the bigger market is actually on the general trade, where they are served now with the wholesalers, distributors, and the kiosks, and all that is still big. If you to compare that with a market like South Africa, where it's around 65% modern trade, this is different. But again, to give a big shout out to the likes of Nakumatt and Uchumi, who clearly were the frontiers of this particular element, and you find that we are way much more developed if we were to compare ourselves with our neighbors, for example, Uganda, where it's less than even 10%, or Tanzania. Nigeria is even worse, however much you actually think about it, it's 6% thereabout. So we are way much better. We are among the top 5 best developed markets. And so this is where the modern trade element comes into play, because in modern trade, we have what is called joint business trade agreements. So these JBPs is where now you find the buyer power issues coming in, and they become a point of discussion. By point that it's where now we start discussing elements of how am I going to grow. We actually discuss, okay, so this is the growth. This is the growth that we are projecting to do together. Then if I achieve that growth, what is my carrot? So there is my carrot that you actually give me, which becomes a rebate. And that rebate, now we write it down. After that, we actually ask ourselves, okay, what is going to be the enablers for this particular growth? So these enablers can be marketing support and all other things. And then we write it down, okay, this is what we shall actually do. Third, we actually now go back and actually say, okay, what other things do we need to do that you need over and above the market? So one of the key things that someone can say over and above the market is how we are going to arrange the shelf. Am I going to be the first on the shelf? Am I going to be given a floor display outside here, or another component outside here? And then we start discussing other terms which are like, for example, there will definitely be a breakage. There will definitely be some sort of theft. And that's where we have things like swell allowances coming in. And the swell allowance is actually that percentage that we now say, okay, there's going to be a 0.5% swell allowance that you're going to decree, you're going to be having for every invoice paid to take care of that. And then we discuss eventually what is called the payment terms. And that is the payment terms that we say that can be twofold. One payment terms can be, I'll be paying you every 35 days, or I'm going to give you a credit limit of X or Y, Z amount. And if you hit whichever comes first, so if the days come first or if the limit comes first, those are things now become well documented. And we have that as what is called the joint business trade agreements. But then comes in the whole scope that we will notice that all the suppliers will be innovating, but the shelf space has always remained the same. If you go to most of the stores that you actually know, be it Junction, in fact, Junction has become smaller. If you go to Westgate, it's become smaller. If you go to, let's say, the Naivas Mountain Gateway Mall or something, because there's more optimization. So the retail space is not increasing. Nobody's actually doing way bigger stores. And so within that scope now starts coming in more competitive nodes. And the reason why now someone also has to justify why I have to be on the shelf. Meaning things called category management starts playing into play. And category management means at times you have to rationalize. At times you have to say product 1, 2, 3, 4, 5, I shall not deal with it anymore, or this category I shall discontinue. And that is where now that active management and how that all relates comes into play, that not all the times will all the suppliers be happy, and how you construe that, whether to actually mean that now I'm abusing my buyer power at that moment, or if I've changed tack and I've seen, hey, guess what? You're actually having more competitive activities with my competitor and have another brand that is ready to support me. Do we actually work together and all that? And that's where now we now start finding retail and the detail bit of it and their interpretation of what this means. Because if you don't supply me, for example, if I ask for 100 items, you supply me at 80 items, and then you're telling me at the end of the month, I've not hit my rebate, I've not hit my gross rebate, but I asked for 100. If I had actually asked for the 100. So those things now become in where now you have a lot of discussion points. And what we have had in the market is we came up with a code of conduct, which was jointly agreed upon by the Kenya Association of Manufacturers, Association of Kenya Suppliers. The Competition Authority actually played a very big role in this, and quite happy that, in fact, it was quite timely when that came into play. All this is where you find now the context of buyer power interpretation. And my parting shot before I actually get back to it is because at the end of the day, we don't want a situation whereby it looks like CAK is forcing an union of two people. Even in Kenya, you cannot force a marriage even of two, even of persons, because at times, yes, you can actually tell that business at times will not work between two parties. And that is the point of now to interpret. When we are now divorcing or changing tact of how we do business, how does that look like? And also, one, I agree to the terms of how someone trades, does that now become buyer power? So, for example, if I say, if you are signing up to be my supplier, you shall be expected to pick up your goods. You shall be doing what? And you sign up to that. Do you now come back again and say, hey, guess what? No, I shall not be doing this. And you're actually abusing buyer power. But you already signed up and agreed because you just wanted to be on my shelf. Thank you. Back to you.
Then here we have Ismail. Good
Evening, everyone.
Introduce yourself and then tell us a bit about the Association of Kenya Supply.
Thank you. So my name is Ishmael Beck, the CEO of Association of Kenya Suppliers. Association of Kenya Suppliers actually is a business membership organization that brings together all suppliers in Kenya to retail chains and beyond. More important, we actually drawn from manufacturers. We have manufacturers as part of our member. We have importers, we have distributors, we have farm producers, and also in that all space, we actually take care of advocacy and lobby on their behalf. We actually began our operations way back in 2006. To date, we have a large pool of members, and that is us in nutshell. Beyond about being a membership organization, we do actually link up to the government on one hand, as a BMO on the other hand. We do work closely with government agencies to make sure that the business environment is actually good for all. That AKS in nutshell. I don't know if you had asked a question or...
Now, we were discussing buyer power, so maybe you can discuss buyer power as it relates to suppliers. What's your experience so far?
Excellent. I can say when it comes to the buyer power, a part of our members are actually SMEs. You have both the big and the small ones. For the SMEs are this smaller group. And how a buyer power adds or buyer proposition actually come or tapping on our users, and especially the abuses. And one of the abuses being late payment. I think that is the biggest area that most of our members are suffering from. And maybe to step back behind, how we came to exist was actually because of a buyer power abuse of late payment. That is in 2006 when Uchumi went under for the first time. And the members or the suppliers then who were supplying to supermarket Uchumi went to government and asked if they can intervene and actually treat with their hope. Uchumi came back.
Are you still there? Seems like we lost him then. I think we'll come back to Dr. Priscilla as we wait. Maybe you can tell us a bit about how maybe cases come to you where there is buyer power and it abuse in place. Are you the one who seeks out these cases, or do people come to you and report to you like there is a case of buyer power here and then you need to look at it and then examine it? So maybe we can start with that.
There are two ways in which investigations commence under the Act. So there are two ways in which we get into investigations. And so one could be because we have received a complaint from a party that is affected by anti-competitive conduct under the Act. Or the authority may, of its own volition, what we call suo motu under Section 31, enter into an investigation process where the authority has good information to justify moving into investigations. And so those are the two ways. One, either receipt of a complaint, or two, of our own motion. And both actually are under Section 31. So those are the two ways in which we commence investigations.
What happens after an investigation? How do you proceed from it? Where do you get the data from? How do you go about researching and communications?
We do get our information from two sources I can quickly identify. One is, of course, the evidence submitted by the party that has presented a complaint. They will come in with some documents, or they will come in with an agreement. In the case of abuse of buyer power, we are able to take a statement. They'll come in with other documentary evidence in the phone, or phone conversations, WhatsApp, etc., etc. But then the authority also conducts a market analysis. We do investigate the market. And I'll tell you why for buyer power. The reason being that in order to establish whether there is buyer power, because before we finally establish that there was abuse of buyer power, there must be that power to be abused. It must exist. And so we must first establish that there is buyer power held by the buyer. And then two, that there was abuse of that buyer power through the conduct that I explained. And so we look into a number of requirements that are placed on us by the Act. At Section 24A4, first we look into the nature and determination of a contract. Then we look at whether there was a request for access to infrastructure. And these are payments to even commence trading. So you must make a certain payment up front in order to start engaging. And third, we ask what price was paid to the supplier. So we conduct an assessment of those three factors, whether they exist. But not only that, We then move on to buyer power guidelines. And I'm just trying to explain this to the listeners and the people who've logged in can see that our investigations are quite thorough, and there is no possibility that the authority could be engaging in a witch hunt or is taking complaints that are not cogent enough or are not deserving of attention. In fact, before I progress, then I will say that we have on occasion, not one, not twice, or not thrice, dismissed complaints received from suppliers. And back in 2021, the financial year 2020-2021, we actually closed investigations against this specific retailer, Carrefour, brought in by 5 suppliers. When we got information which could be verified, was actually verifiable information from the retailer to show that these were actually disgruntled suppliers and there had been some level of collusion. And this is in our records and can actually be confirmed, so that it does not appear that we entertain unhappy suppliers. We do not. We have layer upon layer of standards that we apply. Having finished with the Act, the 3 elements I have listed under Section 24A, A4, which are, of course, how was the contract determined? Was it a negotiated contract at all? Because sometimes we have what appears to be apparent consent. And yet, in reality, that consent was extracted from the party. When I really referred to the Code of Practice, which the authority itself gazetted for the retail sector in order to engender solution of matters at sector level. That Code of Practice contains the word duress a good 5 times. And it bars retailers from engaging in duress or forcing suppliers to concede to certain terms. And so we do have those layers. And I said we look at 3 elements under the Act, and then we're not done. We go to the buyer power guidelines and ask, what is the nature of the buyer and supplier markets? How does the market look? Are there barriers to entry? What kind of barriers are they? Okay. And then we add dependency of the supplier on the buyer. This could be caused by difficulty or challenges in switching costs. So sometimes it's impossible to switch. And I have had people say this supplier was not obligated to continue supplying. The reality is that having locked themselves into a contract, then maneuvering out may involve a certain cost, which is much more difficult than just enduring the onerous terms that are imposed upon the party. And what we have found is that the matters we have investigated are not parties that have quit supplying. The interesting thing is that these parties come to us while they continue to supply, so that it's not that they are disgruntled, they don't want to continue supplying on the terms that are existing, and they have swung out and run to the competition authority, as has been suggested. Many of them continue to supply under the onerous terms for lack of choice. And we look into why. And typically, it's what we call economic dependency under the buyer power guidelines. And then we check issues of whether the buyer is a gatekeeper. And again, there was an allusion to that actually buyers, retailers are an access to the downstream consumer market. And so this supplier may be caught between a rock and a very hard place. But of course, we also consider international best practice. And just very quickly, if I can just take us through some of the samples so that we can get a feel that Kenya is not an outlier. In terms of abuse of buyer power, we're not out there enforcing this new, novel, unfair to buyers legislation. There is, I'll give the example of the UK. Under the Competition and Markets Act, the CMA that Gambi earlier alluded to, that competition agency, because it's an agency for competition, has a grocery supply code of practice, which is actually enforceable under law. And it bars things like, of course, delay in payments, obligations to pay marketing costs, requirement for payment of shrinkage. And this is the UK, okay? That a loss cannot be borne by a supplier unless the supplier is to blame. Clear processes, it demands for clear processes for delisting suppliers, no retrospective changes to agreements, and it also demands that there be fair arm's length negotiation. That is the UK. If I was to take us to Japan, okay? Now, in Japan, under the Anti-Monopolies Act of 1947, Article 19 of the AMA, okay, bars buyers from employing unfair trade practices. And these are listed as including demanding, okay, services or other economic benefits from a buyer, refusing to receive goods. And I know that this is now starting to sound familiar because it's exactly what we also do on this end, requiring excessive rebates, deduction to a point that the supply is supplying below cost. That's Japan. If I was to take us to Australia, under the Competition and Consumer Act, Section 46, there is a schedule which bars retailers and buyers generally from engaging in unconscionable conduct. And back in 2014, and the conduct that the buyers are barred from engaging in is using undue influence, pressure, or unfair tactics to establish a price of goods that is favorable to the buyer while injurious to the supplier. Because of time constraints, I will refer to an investigation into Coles. Coles is a supermarket in Australia, which was penalized $10 million in 2014 and was asked to also compensate suppliers. The penalty was agreed by consent because the retailer recognized that its conduct had breached the law. Finally, South Africa, just down here, Section 8, subsection 4 of their Competition Act, 1998, bars abuse of buyer power, okay? Imposed on a, and the law is very specific, imposed on an SME or a firm controlled or owned by a historically disadvantaged group. And the unfair terms could be on prices or other trading conditions. And so I think the point I'm making is that one, we look at the Act, two, we look at the abuse of buyer power guidelines, and then three, we consider international practice. Due to just the limitation of time, I can't take us to Germany, I can't take us to France, I can't take us to Korea. The point I'm making is that abuse of buyer power is contrary to the law, and the law is the law, and apparent consent cannot cleanse a contract that the law has already illegalized.
Thanks, Willie. I think you had some point on that. And maybe because of that, you can also speak about this. There's some reference that was made in the press release yesterday about the sanctity of contracts. So maybe you can speak to that also.
Yeah, sure. So what we did in the Code of Conduct, we heavily borrowed, as Dr. said, from the British. In fact, we were very clear. We actually used that as a template. We went through for what and made it now the Kenyan way of things and all that. It's quite clear, for example, if there's a payment dispute, how to handle it. We even came up with a tribunal. I'm a member of that tribunal. I've never seen a single case brought to us. So that has never happened. So we already have laws and means within that are actually not used. And at the same time, within the act that we created, the very first sentence there was quite clear. In the absence of a contract agreed between the supplier and the retailer, then this shall apply. So if you already have a plan and you have already signed up, I and my supplier are going to be doing 1, 2, 3, 4. 1, 2, 3, 4. Then if you don't have, that's where, again, now the act protects the supplier from that particular element. So there's that enforceability that we need to actually look at, which says, if I've agreed that I'm actually going to be, let's say, paying either based on credit limit or the period that you have given me. So assuming you have given me 100 million shillings as my credit limit or 35 days, and you have said whichever comes first. And I technically now I'm still within, I've only bought 15 or 20 million. I have 80 million still to go. But the days have arrived and I need to pay that. But if I have not, then I still have a credit of almost 85 that I need to actually get. If you have agreed that, guess what? The marketing will, the enablers to growth shall involve us for every new store that we are opening to give 2 or 3, 4 cartons, and that is what we have signed up on it, then that is no longer an issue of buyer power. It's an issue of we agreed. And that was the plan that we had, not to coerce. So before you sign on that, it actually says, okay, I'm not signing this. There are very many, and I'll actually have to say very many suppliers and retailers who are still not even existing on contracts. In fact, you'll find most of the 1, 2 supermarkets, a majority of them will be almost on a 40% compliance when it comes to sign-ups of the JBP or supplier agreement. Because there are 2 documents here. There's one which is called the supply agreement. That's where you have to discuss all the things, including bribery and also things. Then you have the second one, which is a joint business plan, which is renewable every year, which says now, which is more, it's like a double click on the supply agreement on the actuals and the numbers of what we're actually supposed to do. So the act is clear in the absence of an agreement. So if there is already an agreement, then why should CAK come and tell me this is abuse of power? That is the part that now most retailers are actually finding that we might need to ask ourselves that question. And of course, the third bit, of course, becomes the quantum of, which again, I have to agree, they are in the act. The act says maybe a percentage of revenue and all that. We need to look at them in such a way that it's favorable, because otherwise you can actually find someone who's employed 8,000 people and is also enabling even way many other, like 20x or the same, now facing a closure because of the punitive bit of how that number looks like. In a Kenyan context where we are struggling to create employment and create business up and running, that's why you now have to start agreeing, okay, hey, guess what? We need to also look at the numbers and as far as what that looks like. But at the same time, we also just need to, and that is the only request we are actually having as an organization. Can we respect that element of, if I have agreed with my supplier, this is it, and you have signed up, then it's okay for me to actually have that particular agreement. The issue is when now I'm coercing or not, that now then let's discuss that on the tribunal, which we actually formed.
Peter, like the progress should be the tribunal first before the competition authority. Is that?
Yes, there's a clear dispute resolution channel that is in the act. And in fact, we commissioned through the Ministry of Trade. They actually gave the members. And in fact, CAK is also, if I'm not wrong, has a member in it also. KAM, Kenya Association of Manufacturers, AKS, and RITRAC. So within that component, we now have more and more of us going through that particular tribunal. And then with that, it will make things much easier, because the best way of actually, the first bit, we want we ourselves as RITRAC members to tell our own members, hey, no, you're not paying your suppliers on time. This is exactly, you're actually messing us as retailers. You're giving retailers, but we want to also self-correct our own members. But that has to come in also when we actually know, hey, guess what? There is a problem by supplier 1, 2, 3, 4 on this particular. That is where we have a missing gap. Thank you.
And how many cases have the tribunal handled? Sorry?
0. None has come.
And then how come they're more comfortable if they're going to the competition authority than like coming to the tribunal?
That's a discussion point that we need to have. How do we enable that to come? Well, the dispute, because you'll actually notice that some of those disputes are very small. In fact, if you look at the quantum of the current C4 case and all that, that's a small quantum if you look at the level of trade that the guys are doing in the level of billions of actually doing per year, or even any other of the retailers at that level. So that quantum, you'll actually find it will be something that will have been quickly resolved. And anyway, you find that they've already resolved. And guess what? In trade, we'll always have a lot of ups and downs, because today we'll actually be saying, hey, this supplier who supplies me is the same supplier who is supplying my competitor, but is giving my competitor way much more of a discount, or way much more, and he is ever on a 40% promotion. Do I really need to continue working with him at that particular point, or do I need to, or another way around? Even the supplier feels offended because retailer 1 has done 1, 2, 3, 4, 5, which is off what they had actually agreed. And I'd already bought all the packaging material because I'd already agreed on this number of goods that I need to supply to him, and I'm doing my everything. And right now he's telling me he can no longer honor my LPO. Those kind of discussion points will always be there. The key word is, can we now use the set mechanism before we actually get to where now we're discussing almost $1 billion worth of punish? As in this market, we need all the retailers growing. We are only at 30%. We actually need 3 other times more. We need the likes of Carrefour, whatever, even the Jazza that we've just done now. We need more players within this market to actually be able to create that confidence also within the investment arm of the country.
And since we've been talking a lot about the Carrefour case, it would be interesting to hear what exactly was the case against Carrefour, maybe from this CAK. Dr. Priscilla, maybe you can lay out the case and the details so that we can maybe get to the crux of the matter, and then also get to the point where the determination, especially for the penalty, came to be. Lay out the case for.
Before I lay up the case, one, I am very curious where the clause that says that the code and the law shall only apply in the absence of a contract between the parties is. I'm really curious, but suffice it to say there's no such clause, at least not in the code of practice that we gazetted for the retail sector. Second, there is no tribunal under that code of practice. Let me just clarify what the position is. Matters of investigation, or rather outcomes of investigation, or investigation into anti-competitive conduct is done by the authority. under the Competition Act, all 100 sections of that act. Appeals to determinations of the competition authority go to an independent tribunal called the Competition Tri, and that is where Carrefour had presented an appeal against a determination we made in 2020, and the tribunal ruled in the authority's favor, confirmed the conduct engaged in was abuse of buyer power, breached the Competition Act, and reiterated what the authority had already determined, that the terms in Carrefour's contracts breached the law. That's a tribunal we are talking about. And so possibly what Willie is talking about is a retail trade dispute settlement committee under the Code of Practice. And what that one does is hear disputes, but the disputes that parties present to it voluntarily. And the code is very clear that it does not oust the jurisdiction of the competition authority that is domiciled under the Act. It cannot supersede the Act. And indeed, if there's one who could answer the question why parties are not going to that dispute, because the authority also saw this as an opportunity for amicable resolution of matters in recognition of the sensitivity of the relationship between a retailer and its supplier. And so the hope was that more of these matters that the authority has to investigate can be agreed and resolved. I'll tell you who sits on that committee. The Competition Authority does not sit on that committee, contrary to the implication made. It has two nominees of RETRAC. It has two nominees of CAM. It has one nominee of AKS, one nominee of the Council of Governors, because of course trade being a devolved function. It has a nominee from Ministry of Trade. And the authority set up this code in the hope that the sector would, allow me, quote unquote, get its act together. But clearly, where you have one end that sort of may have a bit of a, allow me again, quote unquote, challenge, complying with very clear law, then it might be a bit difficult for this committee to actually get up and running. But I think I'm done with that. Oh, and on the issue of contracts not being written, paragraph 3 of the code reiterates section 24A7 of the Act. It demands that contracts be written, because unwritten contracts are typically an avenue for abuse of buyer power, because they can be shifted anytime, they can be adjusted on a daily basis almost, because they are not written. And so the code actually pushes and encourages parties to put down their contracts in writing, and even sets out the terms that the parties must include in their contract. I don't want to go into those. In any case, they're already in the Act. Now, the matters under determination by the authority, the two matters, I think they've been pretty much in the public domain, but I'll just run through them very quickly. What happened is that we received 2 complaints against Carrefour retailer, and the complaints were basically that these parties had been enduring and continued to endure. Remember economic dependency that I referred to? They continued to endure conduct that amounts to abuse of buyer power in the form of paying punitive rebates. And in a typical world, a rebate is tool used to encourage a buyer, for example, a retailer, to give something in return. For instance, early settlement of an invoice, or to reach certain sales targets. And so when you have a situation where the rebates are now imposed, they are fixed, and they are being fixed by the party that should not even be fixing them in the first place. There should be an inducement from a supplier who says, I'll give you a percentage of my sales because of 1, 2, 3, not you will give me a percentage of your sales because I am here and I have shelves. Now, so the complaints were basically excessive rebates, demands to send employees, including for overnight stock taking, threats to terminate contracts, actual termination of a contract, because we issued a cease and desist order because this conduct was ongoing. And we told Carrefour in March of 2023 in the Pwani oil matter, please take a pause. Should we find in your favor, you can pick up and recover. Should we find against you, then at least the damage will not have been ongoing on the supplier. And so shortly after we issued the cease and desist order, we gazetted it in March. Carrefour then terminated the contract with the supplier. And what happened is that we have complaints of excessive deductions to below cost in certain instances, excessive deductions of rebates, some annual, and so on and so forth, demands to send employees, and that is transfer of cost. And then we also had threats to terminate because the retailer would refuse to renegotiate 2022 contracts. So either take it or leave it, okay? And negotiation, at least even the code of practice has been referred to. It's very clear. It says a retailer shall at all times, paragraph 2, deal with its suppliers fairly, I'm quoting the code, fairly and lawfully. And that this dealing by a retailer shall be in good faith, without distinction between formal and informal arrangements, without duress, and in recognition of the supplier's need for certainty as regards risks and costs of trading. And so those were basically the complaints, the nature of the complaints that we received. We investigated them and we gave due process to the retailer that was represented by one law firm, and another law firm joined in later. So we're talking a situation where the party under investigation was given absolute due process under the Fair Administrative Actions Act, under the Competition Act, and under the Constitution of Kenya 2010. And so in a nutshell, that's the nature of the matters that we investigated. But you did ask something about the penalty. Now, the penalty, there is that assertion that the penalty is high, it's exorbitant, and we must ask ourselves as Kenyans, relative to what? What is it high relative to? Is it possible that it is because it is outside of our expectations? Or is it, I would really want to know, it's high relative to what? Now, the thing is this, penalties under the Competition Act, Section 36D, enables the authority to penalize up to 10% of the offending party's annual gross turnover for the preceding year. And that is the law. It is the law, okay? But the authority doesn't just toss out the 10%. There are very clear considerations under our fining and settlement guidelines. And they actually require that the authority takes into account various factors, which I can assure you we did. They include, the factors we were to take into account include the nature of the offense, the gravity and extent of it, the duration it has gone on for, the effect on the affected parties and other similar parties, okay? Was there retaliation? Was there cooperation? Those we call aggravating factors. They load the penalty. But we also take into account mitigating factors. And these mitigating factors could be, was there cooperation? Is this a first-time offender? Because a second-time, third-time offender that offends knowing well that they are offending, that's an aggravating factor. Is this a first-time offender? Were they willing? And did they progress settlement? And so the authority took into account all those factors. I wish to say that the penalty is based on what the law allows and enables, and which is up to 10%, but I can assure you it was not even 10%. But finally, I'll say this, that the authority also takes into account that the penalty must be proportionate and deterrent, but while taking care to support the sustainability of the party that we are penalizing. And so if we could just look at it from the angle of what is the impact on the other parties, and the fact that it is a considered penalty based under the law and still below the maximum that the authority can actually penalize.
We're the 1 hour mark and we have a few more minutes to go. That's a very interesting discussion. So if you want to be part of it, what you can do is below the pinned tweet, you can just type your questions, and you can also DM us your questions. We may not allow speakers today because we have enough of them. But if you do those two, we can easily pick your questions and then forward them to the various people who are involved here. So Winnie, I'll give you the chance to respond. I think you're speaking from the supplier perspective. I think the competition is talking about in the sense of there is an abuse of power in this sense from Carrefour. And so from your perspective then, what would you respond to the case against Carrefour in this case?
Okay, so first and foremost, one, again, apology, I use the name tribunal instead of committee. It's actually the committee that actually set up And just to also answer the part which on part 3 of the Code of Conduct on the variation of supply agreements, joint business plan, it clearly states a supply agreement stroke joint business plan shall be a mandatory in the supplier-retailer relationship under this code. And that's where now it starts subject to paragraph 3.2 also. It says a retailer must not vary any supply agreement or JBP retrospectively and must not request or require that a supplier consent to retrospective variation of any supply agreement. And again, when you look at it, even including the marketing and the prices or delay in payments or even contribution to marketing and all that, it keeps on referring to the fact that not unless stipulated within the supply agreement or joint business plan. So here, if you already have a party that has already signed up to this particular joint business plan or supply agreement that we are actually saying it should be a must, then at that particular point, does it become coerced? Should you not use that before you have signed it? So before someone signs it, let that be the time that someone takes that particular process through which says, I know these terms are not competitive, I'm being coerced. But if you've already signed them, you're already trading. Now it's an issue of now renewing and all that. That's a time that now comes in. That means possibly what the retailers are saying, let's have this. And when it comes to the fine, first of all, yes, it's true. It is in the law. They're up to 10%, including most of the punitive in CAK actually on around that 10% mark. Unfortunately for retail, we operate on very thin margins. In fact, retailers in this market will not be making more than 4.5 to 6% margin, which typically means if you charge them 10% within that annual margin, they are shutting down. A 10% charge is definitely a shutdown. You can't even say it's something that you can actually have a payment plan, I don't know for how many years. That's like telling someone, okay, for the next 3-4 years, all what you're working for is for that particular fine. So yes, it's steep. It's something that we might need to actually discuss how some of that looks like. Already businesses are struggling. Margins are lower because of the current macroeconomic situation. We're actually finding that people are banking way much less because the volumes are way less. The consumption has really dropped. So by the time you actually even use last year's number without inferring to the kind of growth that is actually there and all that, you'll find that a business will definitely shut down. But of course, I know that is already in law, something that what will actually say, hey, please, let's reconsider how that looks like in the law and if possible to be able to amend it. But to again put it this way, the committee are set up. That committee and actually properly launched by the Minister of Trade, then if it's put into place and things start happening in there when it comes to supplier complaints on payments, rebates and everything like that, we might actually find that we don't need to get into this case because the quantums are very low at that particular stage. For the mistake of less than 10,000 shillings, you'll be charged at 10%, which is $1 billion. We are looking at a 15 million rebate that's supposed to be repaid back, but you're supposed to pay a fine of 1 billion. It's punitive. Thank you.
No, so Willie, what's the length of some of these contracts that suppliers have with retailers?
A normal supply agreement is signed once off from when you're starting to trade, defines what you should do and what not to do. And then you have a joint business plan. The joint business plan is signed annually and with quarterly reviews. And that is where you actually set your objectives for that particular year. You set your carrots and whips. You set your trading bit. You check out when you shall actually be able to review and all that. So the joint business plan runs for 1 year, but the supply agreement, you sign it one off.
If I get your argument clearly, it's that once this contract is signed, it should be sacred and it should not be taken to a competition authority in that sense. It should be maybe a code of agreement between the supplier and the retailer so that you keep to that until the next time it's about to be renewed, and then we discuss whether the terms should change or not. Is that the argument?
There's always quarterly reviews, and in the quarterly reviews, you change. Within the quarterly reviews, you always can vary 1 or 2, 3, 4 things, which means this rebate can actually not be there anymore, or this law has changed and that this might require that now this will actually change, or okay, you have shifted my space, or you have changed your shop, I'm no longer having the kind of space. So that always keeps on changing, but has to be agreed and signed off. So that sign off, it will always happen. And at times there will be conflict because one party might not be happy with the other. So for example, if someone had agreed to give, a gross margin on flour, and then government introduces subsidy, at that particular point, the miller cannot afford to give you the same gross rebate and still be able to supply at the kind of price points that have actually been put in. Those discussions will always be there. As a retailer, if I'm not trying to look for that rebate, then I'm also not being fair to my supplier.
But then specifically with Carrefour, the Competition Authority argues that they did reach out and say that some of the terms may be punitive on one side. Then if such a case happens, then does the retailer then maybe review the contracts or at least try to do something about it in that case?
I will not comment on the Carrefour and the CK case, but in essence, when any party is aggrieved, people should definitely be able to review.
Okay. Yes, sir.
If you allow me, I've had Willie and Priscilla actually dwell into the whole thing of this power abuse. And that one, Willie, I think we've sat in several meetings with you and we've been discussing this. And it's actually wrong when you say that the committee has not handled any issue. I remember we had an issue with Mulays and we had given the duty to your team to feed us with some information that never came. So actually, maybe you are not so acquainted to what's exactly happening. Now, if you say allow the contracts or allow once a contract has been signed, then that's final. Then what is the reason? What's the essence of a buyer power abuse? Because why should an authority, if not to address issues that are actually mandated by the law for them to take care of? For instance, if a supplier enters into an agreement with a retailer on a 30-day payment, then the payment went to 45 days. It has been violated already. Then should you also say you had agreed, then this should only be between the supplier and the retailer? To my understanding, that is one way to look at it. The other way to look at it is in the event there were coercion, there were threats during signing of these contracts. And if a buyer is that big, they have that muscles, they have that powers actually inside some pressure into signing those contracts, which may not be so friendly or may not be comfortable to the supplier, then should you deny then CAK to intervene in such situation? Then what is the mandate of CAK if not to check on the excess of either parties? Because I know CAK is not only handling issues on the retailers or on the supplier side. They're handling, there's one that's both sides. If the supplier is on the wrong, then they win. When it's a retailer, they win. Now, the reasons why we are having the buyer power abuse is in the law is actually to handle such issues like a powerful retailer inserting some pressure on a supplier to sign a contract that they are not so comfortable execute at some point. That was what I was saying.
I think the key word that you're actually saying as retailers is one. So here you have, and I'll use the Carrefour case. You have two suppliers who have actually felt aggrieved. They have actually gone there and clearly there's now saying, hey, you know what, this is actually not working and this is actually wrong. But after some time, they have themselves, the two parties, together with Carrefour agree. And they even write jointly together to CAK and say, we have now resolved. But it's ignored. Why should you ignore when those two people who are actually having an issue and they have resolved and they're even trading happily and all that? That is the part that retailers are saying, hey, no, please listen to us. We'll always have 1 and 2, 3, 4, as in enable trade and then change bits. So it doesn't look like, hey, because the two parties are now trading with Carrefour perfectly. They're happy. The three parties are happy. No, that's why the gist of the Supreme of retailers, we're just saying, okay, no, just as you actually go on ahead, also just understand that this is not going to be the last case because technicalities will always happen. Someone might have actually imported items and they're stuck in the port. And when he comes now, by the time he's clearing them, already that shelf has been filled by another party and is no longer on that shelf. You'll always have 1, 2, 3, 4 hitches. All what we ask for is fair consideration of issues that when you now resolve our issues, either through the committee or between the two parties, that at least CAK also list.
A couple of questions have come in, as I think I'll give Priscilla some time to respond. One of them is the alongside Willie's question. The other question that they have is, I think Carrefour, when they were responding today, they say that they had actually resolved some of the issues that they had with their suppliers and that they had actually signed in contracts in that regard. So they are surprised about the determination. So maybe you can speak to that as you respond to Willie's question.
All right. Thank you very much. Let me start with the last bit which you have just raised and the one Willie has raised about agreement. Now, the authority is not averse to settlement agreements at all. The record bears me witness. Early this year, we had a settlement agreement with Unilever PLC on buyer power. Very recently in July, you saw news about an investigation into cartel conduct in the steel sector. There are negotiations going on as we speak. And two of the parties are actually in the process of settling. You remember the paints matter. Those were settled The space of the authority is replete with examples of settlements. Now, the thing is this, that in the process of investigation, we received communication. The communication came from the suppliers that, look, we are now talking, we want out. And we wrote to the suppliers and copied Carrefour as follows, that the authority is not averse to negotiations at all. However, Section 38 of the Act is clear that once a matter is under investigation by the authority, any settlement reached will be reached between the party under investigation and the authority. And so therefore, come forward. Come, let us sit at the boardroom at CAK. Let us arrive at a settlement. We will close this matter on the terms of the settlement. There were 3 letters to that effect, with clarifications to the parties time and again. But for one reason or the other, there was a decline, there was a refusal, which then caused the authority to progress. So the option to negotiate, give the example of any other criminal offense. Let's think of an offense that's under investigation, or rather a criminal offense, because the reality is this. Section 24A1, abuse of buyer power is actually an offense. It's just that the authority is allowed administrative penalties. Once a matter is under prosecution before the courts of law, before the magistrate's court, you cannot just appear and declare, now we want out, okay? Because sometimes it's a party being twisted. And so then the legislator was very clear to ensure that parties do not come and then they are threatened and back right out. And so we said, come, let us arrive at a negotiation. Indeed, finally, on the matter of negotiation, many of abuse of buyer power matters go out by way of settlement. Up to 78-79% of our matters get closed on account of settlements, and you don't get to hear about them. And these settlements are between us and the offending party, with the complainant sitting there saying, I'm okay with that. Okay, so that's a bit about the settlement. On the issue of the penalty, the reality is this, that a party that engages willfully, knowingly in conduct which the authority has determined breaches the act, and the tribunal has confirmed breaches the act, then really, pray tell, what are we to do with such a party? A slap on the wrist? I do hope that's not what we are proposing. The other thing is that there was a reference to the fact that the Trade Dispute Settlement Committee is it launched by the minister? Actually, that's not the correct position. The correct position is that once the authority established, gazetted this code of practice, the idea was the parties that I read out sit together, put together this committee where they can hear first level disputes. They have never put it together. And yet there's an expectation that unhappy parties go to a committee that is not operational. Of course, they will come to the authority. Finally, allow me to say that once a contract, a sanctity of contract, agreed, freedom of contract, agreed, but those are common law principles that do not supersede written law, legislation. And so once the law says the contract you've entered into means the law, we can think about sanctity of contract till the cows come home. That contract will continue to remain illegal, regardless of whether it appears that parties are happy, and I spoke about apparent consent, pushed by economic dependency, difficulty of switching, and so on and so forth. And so the reality is that written law is clear. Abuse of buyer power is an offense that breaches the Competition Act, and when engaged in, there will be consequences.
Gambi, I have a question for you. I think there were some numbers you gave me yesterday about how much it takes to open a retail shop and the free goods that maybe a retailer can get at the beginning. So maybe you can repeat that a bit so you can give context to the case.
Thank you, Eric. First, I'd like to clarify something. I think also on your page yesterday, you grabbed some of the numbers that Carrefour has, parent company has publicly declared to be their revenue. So I'd just like to clarify a misconception that's out there that CAK penalizes 10%. Indeed, we have never penalized 10% on any matter. As a matter of fact, I think Eric's on the Mango Capital page, you've done a sort of estimation about where this lies, the penalty lies on the scale of 0 to 10. And I think I saw the number as 2.3. I'd like to confirm that you're not far from the truth. If you check the numbers that you'd given, I think 40-something billion in terms of revenue last year. So if we reach a determination this year, we take the revenue from the previous year. So if you compare the 1.1B vis-a-vis, there are two contrasting figures. I think 38 billion, there was another 40-something. So you're not too far from the truth. It is way less than 3%. Way less than 3%. Had we penalized the 10%, then I think the charge that we want to close down Carrefour could be merited. This time it's less than 3%. You are spot on that. I'd like to reference a figure, last go to your question, reference a figure that the case that CAK won at the tribunal, it was against Carrefour. Carrefour had issued a determination. Carrefour contested it, went to the tribunal. At the tail end, when the members of that tribunal made their judgment, the legal representative from Carrefour made a public admission, requested the tribunal for more time, I think 30 more days, so they could check the possibility of amending the contracts, which we really want them to do. He said our client has over 4,000 suppliers. That's on public record. I've seen a statement today claiming it's way less than that, 700. So here's the thing. Every time Carrefour or whoever it is opens a store, whether or not it's across the street, one is here 5-10 meters away, you as a supplier, whether you supply in 27 of the other branches across the country, you have to pay a listing fee. As you saw in yesterday's press release, a small company like William said, yes, indeed, it's a small matter, but it's a small company, relatively, Woodlands, required to pay 50,000. Whether or not you use the figure of 700 as alluded in today's press release, or you use a bigger figure that they've mentioned at the tribunal of 4, that's free 200 plus million. Check how much does it cost to open a new branch in a retail store. So the question is someone advancing or expanding in the country using suppliers' money? Number two, there's a requirement per SKU. So for instance, there's cooking oil, there's 10 liters, all the way down to 500 ml. Each is an SKU, a stock taking unit. They are not the same item. So the requirement in this investigation that we just concluded, that was for each you provide 2 cartons. At least that was the case for Pwani oil. So you present 2 free cartons. Extrapolate that to 700 clients as per their release, or 4,000 clients or suppliers per their tribunal admission in court or in the constitutional system. You enter a store and you find a product that was typically 600 shillings is being sold at 300 bob. You must wonder how, and it's consistent. The discounts are there. I'm not saying discounts are bad, they are good. It's consistent because remember, this item was provided for free. They could give you for free, for instance, but now they slash it to 300. When the offer ends, it goes back to the other. So there's a disadvantage again to the suppliers. But as I know, I've seen the questions sometimes even yesterday, investors. CAK takes cognizance. Our work here is not to repel investment. No. Our work is the opposite. Facilitate the good working environment for investors. But here the issue is that there are 2 types of investors. Our suppliers, the suppliers in the country, are also investors. The retailers, whether or not they are from abroad or local, or it's Willie Kimani's Jazza, all the best, Willie. It doesn't matter. Willie is an investor. The supplier is an investor. Whose rights should supersede the other? Don't the suppliers have a right? That is the question. So when people are talking about expansion, all that innovation, as Willie was saying, you come up with a new branch, you call it, I've seen the food market, nice, that's good stuff. But why should you expand on the back of suppliers? That's the question CK is asking. And to remedy that, the final issue will be amendment of these contracts. If you go back, we have been singing the same song. We want the contracts to be amended. And that's, I think, the crux of the matter. So in terms of scale, are we trying to kill Carrefour? No. And you also have to look at it that the conduct has been ongoing. I think they've been around for around 7 years. So this value that has been extracted from our suppliers, the suppliers who are supplying to this specific retail store for 7 years, who is taking count of that? How much is it that was more or less illegally extracted from our suppliers over 7 years? So when you now look at it also with the penalty, is it outrageous, as has been suggested? That's out there for people to decide. But 10%, we have never. We have the scale. Well, don't say we are magnanimous, but in this case, we could have gone higher, but we didn't. So I think, and maybe one last rhetorical question. I don't think I want an answer from anyone specifically. There are many retailers in the country. These suppliers supply majority of these, especially the big ones, the Quick Marts, the Naivas, the Jaza, Willy Kemanis, why is it that CAK only receives complaints pertaining to one retailer? Why hasn't Pwani Oil, why hasn't Woodlands complained about Naiva? I suspect the issue is these other retailers, as Willy suggesting, that is a preferred environment. Allow for negotiations. In this case, Dr. Priscilla has just mentioned, issued a cease and desist order. 2-3 weeks later, the guy was kicked out. So how do you deal with such a player? Do we tell them, fine, proceed? Why should we do that? The law is there. We are exercising our mandate under the law while following due process and best international practice. Thank you.
There's a question here that is being asked about that listing fees is a common thing across retailers around the world. Is that true?
Could I
For you, Mugambi?
Could I cede the mic to Priscilla?
Sure.
All right, thank you. The investigations we have and the information we have is actually not the reality. And before we make our determinations, of course, we dig around into international best practice. And we are not the only ones who penalize demands for listing fees. I would refer us just to one situation, and that would be the French Commercial Court determination of 2021 against Carrefour, which was penalized 1.75 million euros for exactly self-same conduct as we are looking at. Probably next time, and hopefully this is where the end is. Next time we have investigations against maybe a retailer. If we could get this information, if we could get the proof from the party under investigation, here is a list of places where listing fees are charged standard and the law concedes, the law allows them, then of course we'd be more than happy to incorporate that into our determination. But as far as, and I listed a number of jurisdictions where this kind of conduct is actually not allowed. So maybe there's new information out there, but so we have dug around. My position would be that is actually not the correct position.
Okay, let's put from a retailer's perspective, it might be the naming or the wording. The key thing is, as a retailer, someone has invested in the whole shelf and everything. So in most cases, what you'll actually find is that there is always that new store that I'm actually creating. I'm creating a new market for you. I'm creating something that was actually not even there for you. And this shelf is forever going to be having a product. And so the negotiation always goes by, is there any store opening offer? Is it a 10 for 1, 5 for 1, or 6 for 1? Depending, some don't give. Some give in form of a delayed payment for the first invoice for that. So there will always be a negotiation which can be construed, and someone else might actually decide, okay, guys, what on my side, I just want to standardize this as a listing fee or not a listing fee, or can there be a carton or two or not, which every supplier has the right to say no. In fact, and actually to say this, most investors are actually, listing is usually one of the worst part for both suppliers and also business owners. Why? Because you'll actually find that at times you find people and suppliers and also buyers, there's a lot of corruption also that happens around that side, which really frustrates suppliers a lot. Because now this is a point that now someone wants to list in a new product into a whole new thing. Instead of actually getting that money, it's a buyer, an individual who now says, kandoni list hii, lazima kukue na hii. And that's why you find, to formalize that, most retailers will actually go for, hey, you know what, there is a proper listing fee that is formalized, is quite clear here. So if you check other markets, yes, you might find they might be using another different name and all that, and the support name. But the reality of is everybody has their own way of working. And I have to point out, even at Carrefour, they don't have 100% sign up on supply agreement, because there are some of the other suppliers who said no to those particular terms and 1, 2, 3, 4, 5. So it's all about that negotiation, and also about telling someone, hey, guess what? No, this one I'm not going to do, this one I'm going to do. And then now coming and raising that whole particular issue. I'm not trying to justify item listing, but what you might actually find is that it actually happens, but in different name.
Yeah, you will. And that is it. Not a joyous thing to fight with the person you do business with. The least that a supplier could do is actually create a rift between the person they're doing business with. This is a retailer. And when it comes to a point where a supplier is actually willing to risk all, it means it was so painful or things are not working. If you say the issues that are being raised by suppliers or take it on a face value that they are not that much weighty, it might not be true. Because when you realize 1, 2 a good number of them complaining over one particular thing over and over, then there is a problem. And when there is a problem, it has to be fixed. And when there is a way to fix it, then that is the way we should. Now, coming back to what you've mentioned, in the retail sector where you have the supplier at one end, you have the retailer on the other, and you have the customer on the other end, these are three parties that needs to be taken care of. And when one is injured, definitely, then, and as I said, if you realize a supplier is willing to lose everything or is willing to lose the business because whatever they are going through is so painful or is not tenable, then that one has gone extreme. That's on the extreme. You've mentioned about the listing fees could be others are using different names, meaning the same. There must have been a reason why that practice is not legalized or is not that legal in most of the, even in the international best practices. There must be, or there has to be a reason behind it. And if we go with that, then we are safe to say, if it is illegal, then allow it to be illegal. Or if it is not supposed to be there, then allow it not to be there. Thank you.
Back to you, Gambi and Priscilla. Someone is asking is about the penalty. Who does it go to and over what period should it be paid? And someone is asking also if Carrefour pays the 1 billion penalty tomorrow, will it continue to open the doors? There are 50 suppliers unhappy with their contractual terms. Will CAK ask them to pay, some may say 25 billion. But in essence, I think in the determination, there was not just a penalty, there was more. I think people are focused a lot on the 1.1 billion penalty, but there's a bit more over there. So maybe you can speak to that, Priscilla.
Just quickly, where would the penalty go? Now, should the penalty be paid tomorrow? This is what happens. That the competition authority is a government agency, and our budgetary support is what comes from the National Treasury. And then there's what is called appropriation A&A. And this comes from penalties and merger fees. And so what we collect, depending again on the budget, if there is a surplus, then that surplus, of course, is surrendered to the National Treasury. So that's where the penalty would go. If Carrefour was to pay the penalty tomorrow, would that be a forgotten story? The reality is that, and thank you for pointing out, that this administrative decision, it's actually an administrative decision, we have really focused on the penalty. And there are a number of other requirements under that determination. One is to refund amounts that were deducted as rebates and as the unfair deduction listing fees and payments for every new branch opened. That is one. But the one that is most substantive and most critical, and which the tribunal has supported on before, the tribunal has affirmed, is that the contracts that enable or facilitate terms in abuse of buyer power should be expunged from the contracts of this retailer. And I think Mugambi pointed out very clearly that so far we receive complaints only relating to this specific retailer on matters of abuse of buyer power. And so this specific retailer has been asked to please modify, amend its contracts to expunge a number of terms that facilitate abuse of buyer power. And so for as long as those terms remain within the contract terms, within the JBPs, then an infringement of the law continues. And so what the authority would do, of course, we would only have to wait until we cross that bridge. But the reality is that as long as these terms continue to be part and parcel of these contracts and continue to be unnegotiable, then there will be enforcement.
Mugambi?
I just feel that there's a need to clarify. I've seen that question several times. Where does CAK take this party? What Priscilla said is that at the beginning of the financial year, you have a budget. For instance, let's say CAK's budget is 600 million. We have forecasted that our A&A, as she explained, merger filing fees, penalties, perhaps we think based on previous trends, we'll get 60 million out of the 600. So it's 540 million exchequer, 68 A. If for whatever reason you collect more than the 60 before the end of June, you cannot spend it. The rule in government is that you cannot spend what has not been budgeted for. If you collect, for instance, you had projected you'll get merger filing fees and penalties of 60. For some reason, there's activity in the merger space, you get 100 million. The rest has to be surrendered to the checker before the end of October. The other rider, before I see the mic, is that at no time has any accused party paid within a month or two. No, never. Typically, like in this case, I think the press release from the retailer in question said they're going to appeal. So the process of appeal, like give you a case 2021, it's still in the High Court. We had also penalized them in that case. We never received that money. However, like in steel, Priscilla said, some have started paying. We are a regulator that listens. Some of them are on payment plans. So even if you penalize 40, 50 million, you come and tell us, you know what, business is not too good right now. Can I pay over 12 months? Can I pay over 15 months? We agree sometimes based on what we've done a self-assessment. We've done an assessment of their book. So we can clearly see these guys can't really afford to pay us 100 million in a month, pay it over 2 years, pay it over one year, things of a sort. Yeah, thank you.
Willie, did you have any responses to any of the points I've made? Willie?
Yeah, I think the most important point is we exist. The only thing that brings us every day to the shop is a product. We will not exist why not for the suppliers. We will not exist if the suppliers don't innovate. They are our partners. They are actually at the heart of everything. Our suppliers are very critical. Negotiations will always be there. People will always have 1 or 2, 3, 4 particular variations. It's all about knowing how things will actually need to be. For example, most retailers, what they have is that the rebates are invoiced, and you actually find that now they send, it's more like you ask for a credit note rather than a payment and you deduct and all that. Maybe those are the kind of trading terms, and within our association, we'll actually start to discuss so that by the time someone is actually paying, it's quite clear they're paying for something that they also are giving a credit note for 1 or 2, 3, 4, 5. We also don't want a scenario whereby you are now being forced to actually stay with someone because you have to trade with them and you did not renew a contract, and you now find there is a supplier who is with you but he's active and you even sign all the documents, but you only give an LPO for 1 box per month so to just show that the relationship is open. It's not good. They just to make sure that you're ticking a box that I'm trading with this person. What you want in this particular environment and why Kenya has always been winning in retail is to be able to have discussion points, have and open those avenues, the committee to actually be in complete use so that we're able to negotiate that bit, and to also appreciate one key thing that CAK has done, which is actually bringing in a lot of sanity. And that discipline that is actually coming in along, you'll notice that there are not many of those particular problems of payments as such and all that. And I have to say, between the Ministry of Trade and the Competition Authority, we have seen quite a bit of that discipline checking in and with most of the suppliers. That said, he's also one of the best paymasters. Naivas, one of the best paymasters also. As in, paying way earlier on time to suppliers and all that is also some key benefits that have actually happened. And to also respond, you'll actually find, yes, indeed, for example, Carrefour and Naivas and other retailers, they pass that benefit of that discount directly to the customers, which is within the whole competitive environment. Customized at the end of the day, it's a competitive environment. We're all trying to actually make sure that we modernize the whole retail market and all. But at the end of the day, it's about communication. It's about dispute resolution. It's about putting in justifications that indeed you will not exist if suppliers don't support you. In fact, if suppliers just pull the plug on you, that's why some of the retailers' deaths were faster than what they should actually be, because suppliers will just say, okay, why am I supplying you and you're not actually even paying me and all that? Why are you having this kind of particular terms and those other things? But when you look, clearly this growth trajectory, all the retailers right now, there has been, MT is actually growing over GT. So there is that need to continue having these discussions, opening up the avenues, and we value our suppliers. Thank you.
Yeah, Willie, thank you for that. I wanted to ask Priscilla, maybe, what are the options now for Carrefour going forward in terms of what are the other avenues open for them once this determination has been made?
I indicated earlier on that there is an independent tribunal, and I do know that Carrefour issued a media statement indicating that they intend to appeal to the Competition Tribunal. That is option 1, which is actually provided for under the Act. And which the beauty of it is that it's a route that's been taken before and clarified the law. And maybe if that option is taken again, there will be an opportunity to clarify the law. The other alternative, Mugambi alluded to it and said that the authority is not about quote unquote killing business. There could be understandable circumstances where may I pay in this number of installments, a compliance plan, as it were. Could we work out a compliance plan over this duration of time where if there are amendments, could we amend within this time frame and so on and so forth. But once the penalty is given, then those are the 2 options available to this market player. And let me underscore that the authority exists for markets, not specifically for market players. And so the authority is keen on a thriving retail sector, buyers that are thriving and suppliers that are thriving. And our business is to regulate markets across the economy. And when markets run competitively and there's increased efficiency and of course followed by economic growth.
And then is court an option here, or is after the tribunals and the courts can come into play?
The court is second appeal. A party again that is not content with the determination of the tribunal can then appeal, a final appeal to the High Court.
We've been going for almost 2 hours. We want to wrap up the discussion. But Mugambi, there was a question for you. I think this question comes up every time we have an authority here. Why doesn't the CAK go after the government in terms of competition and squeezing pending bills and all? So maybe you can repeat the answer to that question again.
Thank you. Thank you, Eric. As you correctly stated, that's a question that keeps coming up. How to respond to it is that the drafters of the Competition Act, in their own wisdom, did not give the CAK the mandate to investigate government. So we are only involved in sectors where the players are involved in trade. The way, unless it's a government entity that involves directly in trade, which in how the law has been drafted, we've not encountered such an issue. We don't go in there. Either way, that said, we play a major advisory role. So for instance, if we find there are new bills, proposals out there that may include competitive clauses, we play a significant advisory role. For instance, one that comes to mind is purple tea sector. At that point, we did an investigation. There was a complaint that came to us. If you wanted to venture into the purple tea sector, you couldn't because the incumbent powerful players in that sector, you had to get a letter of no objection from them. So more or less, who would allow you to come into their nice, juicy space? A letter of no objection will always decline. When we did our investigation, we found perhaps it was being facilitated by some government-backed rules and regulations. We advised that this should be expunged. And when they were expunged, 3 new factories came in. These days, when you go to a supermarket, you'll find purple tea products. That was a direct consequence of what the authority does. But when it comes to delayed payments, we have the Public Procurement Regulatory Authority. That's where that mandate would lie. Anyone who has an issue about payments that government has done could forward the complaints there. And since you've asked about delayed payments, you'll allow me to pat ourselves on the back a bit. At CAK, delayed payments has never been an issue for us. Suppliers can attest to it. You'll allow me to throw that one in. We've never had any pending bills in our books for the last 10 plus years.
On that note also, maybe you should speak to the fact that the general sense is that this ruling, at least, is killing businesses at a time when the economy is not doing so well. That's one of the issues that has come up. Maybe you can speak to that and also speak to the fact that do you actually engage in discussions with people before you make this ruling? It seems to come across to many people as punitive and more like the Competition Authority comes against business, so we can respond to that specific concern.
Okay, let me take it again and I'll try to be brief. Fine, yes. The matter has finally been decided and made public at a time perhaps when the economy is not doing so well, but we've seen no signs of improvement and from the numbers that have been shared recently. This matter, however, started way back in 2021. This one in 2020, at least for these 2 matters. The other matter that is at the High Court was way before that. And I'll reiterate that we are not anti-business. The economic conditions that are affecting the retailers are also affecting the suppliers. Just the same way transport costs have gone up for suppliers, is the same way retailers the manufacturers are facing higher input costs. The retailers are required to pay higher. People are agitating for more wages because perhaps they need more income and all those. So the economic conditions that are prevailing in the country in good and bad times affect everyone in various ways, but they affect them negatively in various ways or positively in various ways. As I said, and what Priscilla said, our work at CAK is to create this business environment that is suitable in the circumstances for everyone. That said, let's not just concentrate with one player whose role and centrality to the economy we cannot understate. We don't say that whoever we penalize is not important to the economy. We became a bit more exercising the mandate. It was changed in 2019, the buyer power mandate. At some point, the law was improved. It was a direct consequence of the problems we had prior to CAK taking up this buyer power mandate. Now, we are doing something about it. We are not here to kill business. We are here to support business. But we say, a retailer is a business. The manufacturers who supply to them are also businesses. Can everyone negotiate in good faith? can conditions that are not merited be deleted, changed, negotiated, period. Let not anyone force terms that are onerous down the throats of other investors, in this case, the suppliers. Thank you.
It's time to do some closing up. Two things. One, I'm sorry that you couldn't allow more speakers. Having 2 to 4 speakers is usually more than enough. Adding more usually makes it a bit of a shouting match sometimes, and it's not good. So we wanted to have a really good discussion. So usually we have 2 to 3 speakers at most. So for the many requests to speak that we received, I'm sorry that you couldn't take them in today. For the many questions that have been asked, we'll forward some of them to Mugambi, and then you can have a look, and the Competition Authority can respond also. But I want to give us time to maybe give us closing thoughts. Maybe we can start with the AKS. You can give us your closing thoughts first.
Thank you. On our side, and as I mentioned before, we wouldn't wish to have this fight with the people we are doing business with. That's the retailers. And that's why during the discussion you would hear in the code of practice, we admit it in a way that the issues that were simpler or could be resolved between the retailer and the supplier, when that is done, well and good. If it doesn't, then it escalates to the association. If it's not, then it goes to the committee. From where we sit, we believe some of these issues could be resolved. It is possible to be resolved. Some, and majority of them actually has been resolved between the supplier and the retailer at their own level. If it is not, some of them have been resolved between the supplier, retailer, and the association. That one has got. We are yet now to exploit the other level beyond now the supplier, retailer, and the association. That is on the committee levels and above. But again, we wish to appreciate the fact that CAK, when they step in and bring this sanity in the environment, we've done a lot of sensitization amongst our members just to realize or to know exactly what the CA are mandated to do and how they can step in whenever there is an issue or could resolve some of these issues. But again, when issues goes to, okay, for instance, then it takes another trajectory which could possibly lead to some way or one way or the other friction between the two parties. But again, the beauty of it is if it will resolve or it will actually come to a conclusive and both parties come to an agreement much better. We are actually ready and ready to work with all the stakeholders in the industry to make sure that the environment that we are operating in, that's a business environment, is good for all. We look forward to working with all other stakeholders in the industry to make the business environment that friendly. Thank you.
Thank you, Mugambi and Priscilla. Any closing thoughts there?
Let me go first, then Priscilla can, I think, talk about the substantive issues. There's a question I didn't answer, but as I said, my closing remarks are just negotiations. Once you guys sit on the table, good faith, CAK will at no point intervene. Willie can attest. We don't go fishing for issues just for the sake. When there are problems, we monitor sectors. That's our work. We have to do it. Because if we don't do it, if we take a back seat, perhaps the problems could be quite just as terrible or bad as they were in the past. Quickly, there was a question about, do we afford people we are under investigation or undertaking under investigations right to be heard? Yes, Priscilla said about the Fair Administration Action Act, the competition law, and the various guidelines that we have. If, for instance, a complaint has come from an external party, we do preliminary investigations, we assess, we request for more information from the complainant, evidentiary information. In this case, we're looking at contracts, we're looking at the rebate, what have been charged over time, communication between the parties, we look at that. If we find there's cause to progress the matter to a full case, we write to the accused party, inform them we have this, and we afford them an initial chance to respond to the accusations. We have sittings with them, all their legal representatives, where we even have a dedicated room for hearing conferences. We sit down. I'm seeing some of the listeners, I can see some notable legal minds who attest to the fact that we invite them to come speak on behalf of the clients, respond to the charges on the table. If there's requirement, if there's need to again go to the complainant for more information regarding the rebuttal, we do that. There's evidence of the back and forth between us and the accused party. We retreat, we do a notice of proposed decision, we issue it to the accused party. If, for instance, we come to the fact that these guys have done wrong, this is a proposed penalty, we give it to them, okay? Again, we offer them an opportunity to respond to the proposed decision. All this in the specific matter that we are doing. It's the modus operandi at CAK when it comes to investigations. We afforded the current party all this. We have replete volumes and volumes of evidence of the engagement. At some point, as Priscilla has mentioned, we reached an impasse and we had to go the route that we did. We penalized within the allowable margin in law. And as I said, the numbers that I've seen floating, going around on social media are more or less close to the truth. The penalty was nowhere near the maximum allowable. It was less than 3%. Why? Taking fact or cognizance that if we penalize them too high, 10%, 9%, the repercussions will be harsh. Thank you.
Thank you. Priscilla, and then Willie.
Thank you, Eric. My closing remarks, one, we look forward to greater cooperation, working together with stakeholders, market players, and as Mugambi has, actually it was Ishmael who referred consistent engagements that we have with stakeholders, especially because we realized that abuse of buyer power is a fairly new area and there's quite a bit of need of sensitization. And your guest today can confirm that in the middle of last month, we actually had a sit down with their members in Kisumu to just clarify what are the issues, what is the law, in an effort to preempt situations such as the one that we have at hand. And so the authority continues to be very key on that, increased sensitization, increased advocacy, so that enforcement is a last recourse. The other thing I would want to mention is that, again, you will recall that it's the authority that gazetted the code of practice for this sector, in the hope that the sector players can actually pick up on it and be able to resolve issues with as little friction or need for bureaucracy. I've seen someone refer to bureaucracy, or with the need to engage with the regulator. And the code is clear that the regulator is only a second tier if the dispute settlement committee is not able to resolve this matter. So mine is a challenge to the guests to please progress this code of practice, seeing that the authority already gazetted it. It belongs to the sector. We gazetted it in June 2021, and it needs to get running. The other thing, as my other closing remark, is that the authority is open to settlement negotiations, but it must be made very clear that negotiations cannot be made outside of the four walls of the authority. Otherwise, it defeats the very purpose of the authority commencing investigations or even the existence of the act. And if there's going to be any negotiation, even in court processes, that determination and the consent must then be presented to the court. And so in the same manner, if stakeholders out there, there's investigations going on, there are two parties on two different ends, and you want to discuss a settlement, Section 38 is very clear. Come to the authority, and the history will bear me witness that the authority does accommodate settlements. But settlement is not parties pulling out matters under investigation, because once they are under investigation, they are actually within the mandate, the authority. Finally, on the issue of consumer prices, fair consumer prices, again, we must be worried. We must ask, where are these consumer prices coming from? And we must be worried of short-term gain in exchange for long-term pain. And allow me to stop at that. Also, just to comment that as a country, as a developing country, what will finally resolve the economic challenges of this country is actually inclusive economic development. And that is only possible where small players, weaker players, are actually able to enter markets and to actually participate in those markets and compete in those markets. And so for that purpose, we need fair market conduct, and we need fairness in competition. Thank you.
Willie, now you can give us your closing thoughts also.
I think to thank everyone and to keep the retail chain moving. All what we actually seek for is that at any one given point, negotiations, discussions, formalize most of the things. The appreciation of what exactly the suppliers bring onto the table is immense to us. At the end of the day, it's all about the customer satisfaction, and all that cannot happen without. Again, as I earlier said, the authority has really done quite well when it actually comes to many things, all the way from acquisitions of new sites and where you have competitors and all sorts of things. And we're all trying to, at the end of the day, just make sure that we're able to service the Kenyan economy much better. Apart from that, to welcome you to the 4th Jazza store tomorrow opening, as we grow the small players also as we fight for market. Thank you very much.
Thank you all of you for joining us on the spaces today on understanding buyer power and its abuse. It's been very informative. Now we hope to have more discussions like this in the near future. Wish you all well in your various roles in the society. All the people in the audience, thank you for joining us once again.